Welcome back to Weekend Dawn with myself, Liezle and Jacob Moshoko. Of course, we're with you between 6 and 9 o'clock here on Newsroom Africa. On Tuesday, the High Court in Pretoria delivered another judgment against Public Protector Busisiwe Mqobane. The case was handed over and the findings, obviously, about the remedial action was ordered into the investigation by President Cyril Ramaphosa with the ANC's presidential campaign regarding the ANC's presidential campaign donations. Now, she found that the President Ramaphosa, in fact, had misled Parliament and that his campaign funding constituted money laundering. She then recommended that action be taken against him. But the report was done in response to complaints made by former DA leader Mmusi Maimane and EFF Deputy President Floyd Shivambu. The High Court then found that the Public Protector did not have jurisdiction over political campaign funding, and she had failed to understand the duties of her office. The EFF has since stated that it will appeal the North Gauteng High Court judgment, which was made in favor of President Ramaphosa, who had applied for the report to be set aside. Now, to unpack all this and more, we are joined by Newsroom Africa's editorial contributor, Karyn Maughan. Karyn, good morning. Thank you for joining us. A little bit of a fumble there in the beginning, but...
No, you held it together, girl. It's fine. I was looking at that and thinking, wow, I could do that.
Let's look at the case at hand. I mean, give us a brief summary of what the court in fact ruled.
Well, this is a long-running matter. It basically has its genesis in November 2018, which was a few months after President Cyril Ramaphosa assumed presidency of the country, where Mmusi Maimane had been asking him questions about the BBS saga. And then in response, in a sort of second round of questions which hadn't been prepared for, basically said to him that he had evidence that 500,000 rand had been paid from Bosasa to his son Andile's account, and he wanted an explanation in the context of kind of a wider issue of nepotism, etc., etc., etc. So Ramaphosa then immediately responds, no, I know what that's about. My son has a consultancy deal with African Global Operations, formerly Bosasa. I know all about this. We've chatted. I've seen it was in his specific contract that he had to sign in relation to, no kind of unethical or corrupt or problematic conduct, wada. And, everything's above board. And if it's not, quote unquote, I will take him to the police station myself. Yeah. A few days later, he then comes back to National Assembly Speaker Baleka Mbete, says, oh my gosh, I made a huge mistake. I've actually been informed by my advisors that this campaign actually, in fact, is one linked to the CR17, my election campaign. It was a donation to me, and I'm correcting this. My money then lays a complaint under the Executive Ethics Code, which says Ramaphosa not only deliberately lied to Parliament, but that these campaign donations, the way in which they were made, my money contained it through various accounts, etc., led to a suspicion of money laundering. The Public Protector supported him in both of those averments, but she gave a report which the President contended and the High Court has agreed was both legally and factually flawed. So just on a simple issue like she said that he had deliberately misled Parliament, and then she said he'd inadvertently misled Parliament. And she literally inserted words. The word inadvertent is not in the Executive Ethics Code. It's that you willfully or deliberately mislead Parliament. You know you're lying, you go there and you lie. And the court said on the basis of the evidence, why would he then go and deliberately lie, like a few days later come back, say, oh, I'm sorry. And they said in the context of the question, it's quite understandable that he maybe made the mistake that he did. So they just said evidentially, no evidence he lied. Plus, because you're inserting all these weird words in the Executive Ethics Code that don't actually exist, legally we have a problem with that finding. So that was that on that finding. On the money laundering, they were like, first of all, you have used the wrong law on what governs money laundering, because money laundering is defined according to the provisions of Prevention of Organised Crime Act. But she used PREGA, which is another act which makes no mention of money laundering. So that was problem number one. Then problem number two, they said on the facts, first of all, there wasn't a big movement of cash around with these accounts. It was a pretty direct payment, number one. And number two, money laundering is the deliberate concealment of the proceeds of crime. So you and I are running a drug enterprise. We need to explain to the people where we're getting all this money from. So we say, look, we have a hair salon, and that's our vehicle for money laundering. Yeah. Not that we have ever done this, but you know what I'm saying. So it's like we know we're getting this money from somewhere dodgy, and we're cleaning it. And to say, they said, in the context context of the funding of this multi-million rand funding of a campaign, there was no way that you could say that that was the proceeds of crime. Maybe in the limited sphere of Bosasa, but she didn't make it was just about Bosasa. It was about the entire campaign funding issue.
So Parliament has finalized the process, but she now wants to stall this inquiry. I mean, on what basis?
Okay, so she's facing an inquiry into her fitness to hold office. Correct. We know that Parliament recently formalized rules for the removal of the head of a Chapter 9 institution, because this is the first time in democratic history that this has happened. She has now brought an urgent application, which I think will probably be heard next, or the 25th or the 26th, 27th. They're still deciding on the final dates. But she wants to stall the inquiry process because it's a whole, there's a whole kind of complex way in which this is done, and if they decide to go ahead, not go ahead, etc. She's saying, no, I have a fundamental difficulty with the rules. I think they're unconstitutional. I have a very, a number. I mean, the application is over 100 pages. It's a lot of issues. But essentially she's saying, pending that challenge, I want this inquiry stopped so that I can challenge all these issues about the inquiry into me, and then you can bring the inquiry. Thandi Modise, who's the Speaker of Parliament, saying nonsense. We need to proceed with this, and we are opposing your urgent application. So it's a very, very serious matter, and one has to wonder how this judgment will play into the motion of the motion that the DA has already brought for Busisiwe Mkhwebani's removal.
So walk us through that removal process. I mean, in terms of seats, we know the ANC has about 230, if I'm not mistaken. The DA also has over 84, if I'm not mistaken. So together, of course, you can see that would make up about 2/3 of the seats needed for that removal. But do you think the ANC, with the factions, the division that's currently, reflected in the party, do you think they're going to come together and perhaps unite on this issue?
Well, a number of, like Supra Mahumapelo, has come out and very much vocalized support for the public protector. There have been a number of people who have come out and vocalized support for her. Whether that support translates into them voting in her favor in this situation remains to be seen. I'm not 100% sure that will be the case. But certainly it's a kind of game of chicken for both, for the public protector, potentially for the president, because the political consequences of that vote failing will literally send a resounding message that he does not have the trust and confidence of the MPs in Parliament, and that has profound implications in terms of just even getting policy and legislation passed, etc., etc., etc. So the process for the removal is basically, at this point, the Speaker has looked at the motion, the latest motion submitted by the acting chief whip for the DA, Natasha Mazzoni, and said, look, I do think there's a basis for a potential investigation, but I will appoint an independent panel made up of people, that are recommended to me by all the political parties, a judge, a potentially retired judge, and they will look at all the evidence and see whether it falls within the ambit of what could constitute gross misconduct, impeachable conduct. Remember, of course, that the grounds for the DA bringing this motion are that the public protector is incredibly incompetent, and they have basically used the judgments in the Reserve Bank matter, Estina, and another case involving the Financial Services Board, which the public protector did not in fact oppose, to make an argument for why she should be removed. They've also used the evidence given by her own staff members, about 7 or 9 different people who've given evidence about her management of the Office of the Public Protector. That panel then makes a decision. They make a recommendation to the Speaker. She then, and then there's a formation of a committee if and when they decide to go ahead. That committee puts together a report. The National Assembly votes on that report, which follows an investigation. Now, the exact nature of the investigation, we don't know, who's going to call, well, etc., etc. But a pivotal thing to remember is that the public protector contends that the judgments themselves cannot be used as a basis for the removal. And the Speaker agrees. She said, well, yes, exactly, but we will lead, if this process proceeds, we will lead evidence around those cases, which, if that happens, could prove to be quite fascinating.
So the EFF is going to appeal the judgment set aside by the High Court, the Gauteng High Court. I mean, on what basis? What are the arguments that they have put forth?
There's a lot of legal technical dimensions to this. For example, one of the things that the court said was that because of the serious nature of the remedial action that the public protector ordered against Ramaphosa, she was obligated to give him a hearing about the remedial action. And that's not in the provisions of the Public Protector Act. To say that you need to do that. And it's got incredibly big implications, for example, the Pravin Gordhan matter, because he makes the same argument. The iPad matter involving Robert McBride makes the same argument. The matter that's being brought by Mpumalelo Racing, the big horse racing case where they're seeking 25% personal cost order against her. They say, she gave this far-reaching wanted the president to order a complete new independent regulatory body for horse racing, and they were never consulted. So if that particular finding stands, it means that all of those people are already walking into those court cases with a substantial kind of legal win in their belt. So the EFF, I think, will challenge that kind of issue. They're going to challenge this issue around her jurisdiction, that she didn't have the jurisdiction to investigate the private funding, like the so-called private funding of Ramaphosa, because it didn't involve, public money, etc. So there is a lot there, and I think I would be very surprised if, for example, the Constitutional Court did not decide to hear this matter, or the SCA decided not to hear this matter, because I think there are points that are legally contentious and haven't really been ventilated to the full extent yet.
Karyn, looking at the current situation at the Public Protector's Office holds, and perhaps what's being reflected through that, do you think this somewhat taints the work or the previous work done by its forebearers?
I think that the issue right now is that the Public Protector, she's being held personally liable for
Yes.
I think it's in the region now of 200,000 rand. It was reported as 900,000 rand, but it's been substantially reduced in the Reserve Bank matter. She faces a personal cost order in Estina, but her office is also 62 of 135 reports are being challenged in court. That's nearly half of them.
Yeah.
And that's unsustainable. So, and also this is an office that doesn't have money. It's an office that is very, we're in an austerity environment. There are huge amounts of money being funneled into court cases, being funneled into these urgent applications. So for me, it's a thing of at what point does everything just shut down because of those cost implications? And I think, the saddest thing of all is that the Public Protector is set up to protect ordinary citizens against the excesses and abuses and malfeasance of the government. What has now happened is that it's become this kind of big political, drama that's played out. And, between, the Public Protector's taken issue with the President. I mean, there's been accusations and counter-accusations between the Public Protector, the President, Minister Pravin Gordhan, the former Rural Development Minister, Thandi Modise. I mean, she said Thandi Modise had an ulterior purpose in, initiating this motion. Shamila Batoy. This is a constitutional crisis, which I don't actually know how it could possibly get any worse. And the people that suffer the most are the people who are trying to go to the Public Protector to get their ID or to get their payments for grants or to sort out where they're being mistreated. The poorest of the poor, the most desperate. And this kind of situation for them, more than anyone else, is devastating.
Time is unfortunately run up. I just want to know in conclusion what this looks like for the future of South Africa going forward in a democracy such as a situation obviously we find ourselves in.
Well, obviously, this inquiry is going to be pivotal. It is very sad that we are now having the removal of the Public Protector, but potentially. But it needs to be resolved as soon as possible so that everyone can move forward and that the Public Protector can either go on with their job having been vindicated and exonerated, or they can try and rehabilitate this entity's reputation, which is already struggling at this point.
Karyn, thank you very much for joining us. Of course, editorial contributor Karyn Maughan chatting to us about the EFF, who will appeal the judgment set aside by the Gauteng High Court. On that note, it is time for a quick ad break. We'll be right back after this. Stay tuned.